preservation of and increased access to the 92nd Street Y Humanities Audio Archives is generously funded by the National Endowment for the Humanities.
Good evening. I'm Leanna Morit, and on behalf of the 92nd Street Y and the Bronfman Center for Jewish Life, I'd like to welcome you to our lecture tonight on the Jewish legal decision-making process, legal and extra-legal dimensions it's called, with Rabbi Daniel Sinclair. Before Rabbi Sinclair begins, I'd like to let you know about two upcoming events, one tomorrow evening with Professor Shalom Paul, who will be speaking about the ever-alive Dead Sea Scrolls, which will also be broadcast via satellite around JCCs around the country on 92nd Street Live. It's one of the things that we do here. And next week, you'll consider joining us on Tuesday the 15th for an inter-seminary dialogue featuring the presidents of three major Jewish movement seminaries, the Reform Movement's HUC, the Conservative Movement's JTS, and Orthodoxy's Yeshiva University. That's next Tuesday night, the 15th. An important aside about this evening. This lecture is the last in our series entitled Do the Right Thing, Seeking Moral and Religious Guidance. And this series is made possible by the support of those honoring and keeping alive the memory and the values of Lena and Max Horowitz. And this wouldn't happen but for them, and I'd like to publicly acknowledge and thank that here tonight. Tonight, however, is Daniel Sinclair's. Ordained as a rabbi in Israel, he also holds law degrees from universities in England, Australia, and Israel. He's held academic positions in the field of Jewish and secular jurisprudence at the Hebrew University, Edinburgh University, King's College in London, and here in New York's Fordham University School of Law. He's also served as the Dean of Jews College in London. Teaching, lecturing, writing around the world in fields of biomedical law, medical and legal ethics, the relationship between Jewish law and the modern Israeli legal system, and that between halakha, Jewish law, and ethics. He's also published 4 quite distinguished books. In addition, Rabbi Sinclair has offered the important perspective Judaism has to offer the world on biomedical ethics to Britain's House of Commons and Israel's Knesset, specifically on the subjects of stem cell research, organ donation, and artificial reproductive techniques. Please join me in welcoming Rabbi Dr. Daniel Sinclair.
Thank you, Leanna. I'm going to present my lecture this evening by way of a number of case studies. So we'll begin with the cases, and feel free to engage and respond, and we'll then move on to something of an analysis. So without further ado, let me take you to the city of Haifa. It's 2:30 a.m. and a car draws to a close on a dark street corner. Man emerges carrying little packages, little plastic bags. Another car stops at the same street corner. Man emerges carrying wads of money. The wads of money and the little plastic bags change hands. The cars speed off in opposite directions. This is multiple choice. Okay, A, B, or C. Is this A, the sale of leaven before the feast of Passover? B, is this the giving of gifts on the festival of Purim at the non-halachic time of night? Or C, is it something else? And if so, would you care to tell me what the something else is? Now, this is asking for some streetwise New Yorkers to show their expertise. Do I have any offers from you people? A, B, or C? C, and we're straight to drugs. Okay. You are? Terry. Terry, let's see, because we'd like to test your streetwiseness, if you're a real New Yorker. Say you are the drug dealer who's desperately driving away from the police, and you have quite a few little plastic bags with raw heroin on your person. Terry, what would you do? The police are about to gain on you and they are going to catch you. What would you do? As a streetwise New Yorker dealing in drugs.
Open the window and throw it out?
Don't go in for a career on the street. Terry, stay where you are. You'll do a lot better there. Do I have anybody streetwise here? Yes. Who are you? Ellen. Okay, Terry, listen carefully. Ellen.
Go faster.
Go faster. You can't go any faster, and the police are rapidly gaining on you. Can't go any faster. Terry, stay off the street. Do what you know how to do best. The gentleman at the back, you are? Let's elide that point, but let's say yes. There's a strong suspicion that a crime has been committed without pressing on the legal side. I see this as a really upmarket crowd that we have here. Hello? Who was that? Who was that? Gentleman at the back. Your name is? Norman. Norman says swallow the drugs. Terry, listen carefully. You swallow them. You swallow them. Ah, that's a medical question. But the first thing you do is you swallow. You hope that you will get away with it, that the police will grab you. They won't find any drugs, so they have to let you go. Correct, Norman? Correct. But what is the medical consequence of having several rather cheap plastic Israeli supermarket bags from Schupersal nestling in your gut? What do you think the medical or biological, physiological consequence of that might be? Anybody care to try the medical side now that we've done fairly well on the streetwise side, but some people, as I said, should stay with a different career? Are there any medical experts here? Death. Very, shall we say, high and die? Would that be a good way of doing it? First of all, the bags will burst. Then the contents will start to enter your bloodstream. They'll make you feel good. And then when you get an overdose, they will no longer make you feel good because you won't be feeling anything. High and die. Shall we? I'm going to cut you off, but I promise you the first right of reply to my next question. Okay? You are? Anita. Okay, Norman, you're paying close attention. Good. The police do catch our suspect, and they do recommend invasive stomach surgery, Anita, to take out the drugs, to save the drug dealer's life. He is still competent, not yet high enough to be incompetent. And he says, no, I know that my life is in danger, but do not lay a scalpel upon me. Okay? He's made his wishes clear. This is a competent adult whose life is in danger. The recommended medical procedure is stomach surgery. And the guy says, no. As an American physician or lawyer or citizen, what would you say? Should the police surgeon go ahead and operate against the wishes of the guy whose life is being saved, or should they listen to what he has to say and leave him, as it were, to die? Remind me of your name? Ellen. Okay. Are you following? Anita, what is your gut instinct, if I can use that term? And your gut as a physician working in the democratic legal system we have in this country would be? And might you be charged with assault? And might you find yourself in trouble with your ethics committee? But you'd still go ahead. You'd like to believe. That sounds already, I'd like to believe that, but would you risk your profession, your bank account, your future? It's tough, right? Exactly. Call a judge. So we do, in fact, get a judge. Now you feel better. Okay? But what happened? Our friend did indeed have the surgery, and Ellen, he emerged into the arms of the police. And they charged him with a drugs-related offense because they had opened up his stomach, Terry, and found the evidence, correct? Now, what would you do if you were the drug dealer and you were charged in court with a drug-related offense in the circumstances that I have described? The gentleman at the front, you are? Reuven. I think that you're cluey and into these things. What defense, Reuven, would you give? Against your will, and you'd say that the drugs were obtained from somewhere else where they shouldn't have been obtained. Illegally obtained evidence, right? And therefore they can't be used. What do we call that? The fruit of the poisonous tree. I hear the attorneys whispering in the background, okay? The fruit of the poisonous tree. So our friend says you cannot use the evidence to charge me because I said no, you operated, albeit I needed to save my life. But the law in this country, as you know well, says you can't touch a competent adult without their consent. And this is a basic democratic principle, and we can cite the Constitution, correct? Reuven and Terry. So, Norman, the case came before the Israeli Supreme Court. And the Israeli Supreme Court considered the democratic case on the part of our defendant. And they said, quite correct, from a democratic, liberal, North American point of view, this is illegally obtained evidence. And we may not use it to charge the drug dealer. But one of the presiding judges was a man called Moshe Beisky, who was in fact saved by Oskar Schindler. He's a little guy that comes up at the end of the film to pay homage at the grave. He was in fact a forger for Schindler, went on to become a Supreme Court judge. I don't know that there's any connection in the career paths, but Moshe Beisky said, this is a case of first impression in Israel. And we have a law, it was passed in 1980, the Foundations of Law Act, which says that when a judge is presented with a case to which there is no clear answer in existing case law or statute law or by analogy, then the judge shall turn to the principles of justice, equity, freedom, and peace of the Jewish heritage. What does the Jewish heritage say about this case? Let me take you to the synagogue or the temple. It's a Saturday morning. Service is going full blast. An elderly gentleman collapses. A cry goes up. Is there a physician in the house? Everybody runs forward and there is a declaration. This gentleman has to be taken to hospital on the Sabbath day immediately. Life is in danger. The old gentleman asks for a blanket and a glass of water and says, I'd like to lie here calmly until 3 stars emerge in the night sky. And then you can take me to hospital. I'm an observant Jew. I've never used a telephone on the Sabbath. Nobody's used a telephone on my behalf. I've never traveled in a vehicle on the Sabbath. Nobody has driven a vehicle on my behalf. I feel, I desire my personal autonomy drives my request that you desist from all action. I feel a lot better. Now, put on your halachic hats. Terry, Reuven, Norman, Ellen, Anita, Michael, Rachel, Eitan, Eliana. What would you say as a halachist? Wow, the rabbi drives the car. You mean we trample democratic rights underfoot? We don't give a straw for what the gentleman says, and he's pushed into the ambulance and taken to hospital, kicking, and the rabbi drives. Wow. That is indeed the Jewish tradition. In fact, a rabbi who neglects to teach his community, the first thing is that when you have an issue of life and death, you must not ask a question, you save life. Don't go and ask the rabbi. But if the rabbi knows, he is the one who drives. Absolutely. So, from a halakhic point of view, Anita, you've got your answer, you think. You go ahead, you coerce, you save people's lives, even when they say no, no, no. And this law applies both on the Sabbath and in the week. It's made clear to the gentleman concerned there's no prohibition. He says, but I feel, I want, I desire. Doesn't matter. Interesting, isn't it? When we are Democrats, we pay attention to what people want. But as soon as we put on our halakhic hats, we ship them off against their will. Justice Baisky said that this is a principle of Jewish law. Indeed, there is a difference between the North American way of looking at things and the Jewish law way of looking at things. Under the North American approach, your life is yours. Under the Jewish traditional approach, your life is a gift of God, and you are a steward of your life. You may not allow that life to be taken because it is tantamount to destroying God's property or allowing God's property to be destroyed. And by the way, this idea occurs in ancient Greek thought. It's mentioned in Plato's Phaedo, that the gods do not allow their property, which is your body and life, to be disposed of as you wish. So, we have prohibitions in Jewish law against suicide, against self-endangerment. Maimonides says in his wonderful way, En nafsho shel adam kinyano hu ela kinyan hakadosh baruch hu. Man's life is not his own property, it is the possession of the Almighty. And therefore, as somebody says, if I wish to endanger myself, quoting Millsian philosophy, the philosophy of J.S. Mill, why should it matter to anyone else? Maimonides uses those words. He says, we do not pay attention to that person. It does matter. And they are obliged to save their lives. They are obliged to have their lives saved. And those who can save their lives are obliged to intervene and to save. You may not stand idly by your neighbor's blood. It is the good Jew, not necessarily Labriut Ruven, the good Samaritan. And we have a law in Israel called the Do Not Stand Idly By Your Neighbor's Blood law of 1996, which says more or less that you must intervene. And those who saw the last episode of Seinfeld, remember when they saw the taxi driver being robbed? You're New Yorkers. Saw the taxi driver being robbed and they stood there laughing. Instead of ending up in Paris, they ended up in jail. Boston is in Massachusetts that has a law similar to the Israeli law. You have to intervene. And so, Jewish law insists that the operation was carried out fully and entirely legally. And in this clash between democracy in the North American mold and Jewish law triumphed. Not that there was a competition here. The Israeli Supreme Court sought to find a way for dealing with one of the very basic ethical, moral, religious, and legal principles, the autonomy of the individual as against the interest in saving and preserving life. And I guess what Justice Baisky was saying was that in a Jewish state it is incomprehensible that the law should not contain and articulate the value of human life, certainly in a case where everything stood to be gained and very little stood to be lost. Now, I'll explain what I mean by that. Does the obligation to keep people alive apply across the board to each and every case of a young, healthy, strapping criminal such as the one we talked about, or an elderly or very sick person whose life is a living hell on earth? Now, here Jewish law has a finessed position. Jewish law is cognizant of the fact that at the end of life or in a terminal condition, then mercy is a prevalent value. There is, of course, a distinction that we encounter in almost all the legal systems we know between the direct act Ellen, and the indirect act. We will allow treatment to be withheld. Certain circumstances we will allow it to be withdrawn. We will never allow a positive act of killing, but at the end of life, in the period known as gesisa, the end of life, then the obligation is relaxed. Traditionally, certainly in terms of Orthodox halakha and in terms of some branches, some views in conservative halakha, it is never permitted to terminate life support. That is the basic air, food, and water. But there is a remarkable response by the late and sainted Rabbi Moshe Feinstein, who was a resident of this very city, except on the lower side rather than the upper side. And in a landmark responsa Igrot Moshe, Choshe Nishpat, number 2, subsection 74, Rabbi Feinstein deals with the case of a competent adult who has very little time left to live and does not wish to be artificially fed and is traumatized by the idea of having the artificial feeding. What does Jewish law say about this? And using the many sources that deal with the treatment of the dying, Rabbi Feinstein comes to the conclusion that this man's wishes are to be honored and respected. And his view is articulated elsewhere, but his view, which is articulated in Responsa Igrot Moshe, Yored De'ah, number 3, subsection 136, is in a different context, but it undoubtedly impinges upon his decision. Rabbi Feinstein's view is that in cases where there is a clash of legitimate values, then the divine ownership of a body or a life passes to the individual, and they will decide what shall be done. And here there's a very important distinction to be made, but I'm going to repeat to make sure that you are with me. We've said that one's body and one's life are the possessions of the Almighty, of God, and therefore you may not dispose of them except insofar as it is in accordance with God's will. Martyrdom, for example, but not suicide and not self-endangerment and not refusing to receive medical life-sustaining therapy. But if we are dealing with a patient in a terminal situation where the remaining period on earth will be fraught with suffering, there's no way we can restore their health in any meaningful fashion. All we can give them is a little longer before they die. And they request to have life support, and I'm being very specific here. We're not talking about withholding. We're not talking about not amputating a gangrenous leg or not giving antibiotics. We're talking about stopping the flow of artificial nutrition, which means that the individual is no longer going to be alive. Okay? We're going to do all the things that we can to make the process easier, but they are going to die. Rabbi Feinstein says, yes, we may. If the prospect of having his wishes overridden, even by a very well-meaning family or a very ethical physician, okay, we will still go ahead. Because in cases like this, where there is a tragic choice to be made, the halakha, Jewish law itself, says that one of the important components in the final decision in the psak is the wishes of the patient. And let's make an important distinction here. Under North American liberal legal tradition, autonomy is an ideal to which the law and ethics ought to aspire. Correct, Terry? and Ellen and Anita and Norman and Reuven and Michael. And we go back to Rachel and to Eitan. Autonomy is what we aspire to, Liana, correct? That is the ethos of the American tradition as it is now. The patient is now center stage. We spend a lot of time giving them information, which I'm going to add as an aside. Anita, they very rarely understand. They always forget. They're often seized with a whole emotional storm to do with the fact that they're so ill. And they make the decisions on the basis of the least relevant factors because we are all human beings. But leaving that aside, the law insists that the physician spends time and resources, and there are long forms to be read and to be filled so that there is informed consent. That is the ethos. The ideal is autonomy. In the Jewish tradition, the contribution that we make to modern thinking in this area is that autonomy is not an ideal. We begin with our starting point is the value of human life as a God-given gift. But halakha is rich enough and finely texted enough to be aware there are cases in which the obligation to live clashes with an equally relevant moral and religious value. Rabbi Feinstein goes to the Talmud. He says a person on his or her deathbed wishes to dispose of their property in a way which is not in accordance with the formal requirements of the law of wills. But they really want to give their property. And they are dying. But we don't have the lawyer and the forms and the witnesses and the seal and the stamp. Are we going to say no? Talmud says, of course not. We will honor their wishes. Shema yitrof da'ato alav. Lest the individual die in a storm of horrible emotions. We don't want that. Dying has to be taken into account in the same way as living does. And so we have an interesting contribution to the debate in terms of autonomy, in terms of the Jewish liberal tradition on one hand, and the American liberal tradition on the other hand. Because Judaism does have a liberal tradition, just has to be teased out, okay? And it may be better to start with the obligation to live, and only in hard cases get to the right, as it were, not to have life support, than to do it the way we do it in our North American and democratic ethos, which is to say, it's all there, it's all yours, you live, you die. Because after all, the law has an educational role. Where do we take our fundamental moral and ethical issues? We take them to the Supreme Court. Abortion, stem cells, the right to physician-assisted suicide, and how honest we are going to be in the workplace or how not. It's all in the hands of the Supreme Court. The law, therefore, has an educational role, not only a purely dispute-resolving one. And we might think again about autonomy writ large in this type of case. Interestingly enough, the Israeli 1996 Patients' Rights Law, Section 15, subsection 2, does codify the Jewish halachic tradition of the obligation to save life. And under this 1996 Israeli law, Norman, a hospital ethics committee may coerce life-saving treatment, provided that the patient receives a full account as if he or she were consenting. Of course, they may not listen, but okay, you tried. That the medical experts all agree, it is unanimously held, that this treatment will save the life of the individual concerned. And finally, this is interesting, that there is a reasonable prospect that after the treatment, the patient will consent retroactively after the fact, will say, thank you, doctor, for saving my life. I didn't really want you to, but now I've had a chance to realize what I would have lost had I not agreed. I say thank you. Of course, that's from the physician's perspective. not from the patient's perspective. It's an attempt by the legislator to try and bridge the gap between the two. And by the way, there is a Jewish law source. The Tosefta in Tractate Shekalim says we force people to pay their temple dues. Okay? We force them. Why? The analogy is made with somebody who needs an a leg amputated. And the rabbis say, nobody wants to have their leg amputated. But after it is amputated, and they realize, A, that their lives were saved, and B, that they can live, then they will say, lemafreya, retroactively, thank you, doctor, for saving my life. A combination to synthesize and to combine, that was my teaser. Now we'll get to the main case. Okay? But Norman, you're on first.
What is the Jewish view in the case that you pose of doctors imposing treatment on a patient against his will if the doctors know that, yes, they will save his life, but he will live as a vegetable?
The case I gave you was a carefully selected case. It was very obvious that carrying out the coercive treatment would only be good. So my answer to you is very straight and very simple. As soon as there is a risk of anything of an untoward nature, the risk is a substantial risk or even a medium risk, there is no Jewish law mandate to coerce. We're only talking about a case where it is very clear that coercion is all good, okay, and is not going to do any medical bad. You can tell me there's a certain risk of any general anesthetic, I agree, but that certainly pales into insignificance when compared with the high and die scenario we described before. You're quite right. Any risk, and certainly making somebody into a vegetable, is not going to be a mandated course. Now, you might ask me, what does Jewish law say about somebody who is in a PVS state, persistent vegetative state? What are you meant to do then? I'd say that would be a very interesting question and is another lecture. So shall we move on to the next case? Okay, I have your mandate. Thank you, Norman.
What happens
Yeah.
if the choice is amputating 2 legs and the patient says, that's worse than death to me. I don't want to live without legs.
That is a much more germane example. Here again, I'd say, no question. This is not a clear-cut case. I don't think there would be coercion here. Because coercion, according to Rabbi Jacobovitz, is only meant to be applied where a holistic view of the patient points to the conclusion that no harm will ensue. And so psychological and emotional and all sorts of other factors will be taken into account. In fact, he says coercion is not on today. The only thing we're talking about is perhaps an attempt for the family to come around the bed and to try and convince someone on religious grounds. You are an Orthodox Jew, these are the values, and therefore you should submit. There would not be coercion in a case like this. Let's try you in Haifa. We'll stick around. We have a couple called Ruti and Danny. Okay? Ruti and Danny are trying to have a child and have been for many years. Unfortunately, without success. This took place about 10 years ago. Ruti was then diagnosed with a severe medical condition and her womb was removed. Prior to the removal of the womb and under hormonal stimulation, a number of her eggs were collected, fertilized with her husband Danny's sperm, and stored in the fridge. Okay, minus 190 degrees in liquid nitrogen. Do not leave the door open. Okay. Now, there was then, of course, the only option left was for Ruti and Danny to find a surrogate. But Israel at the time did not permit surrogacy. So the request went to the US. And a clinic in California was prepared to accept the fertilized eggs and implant them into a surrogate mother's womb, and then the resulting baby would be sent over to Ruti and Danny, who would enjoy having a child of their own. Since this was illegal in Israel, the Supreme Court had to consider whether it was going to allow such a step, that is, the dispatch of fertilized eggs from Israel to the States. And by the time the Supreme Court came to its decision, Danny had left Ruti. He was still legally married, was living with Orna, also in Haifa, and had a baby girl. So when the time came for the eggs to be dispatched to the United States, Danny said, I don't want these eggs to go out because I don't want to be a parent against my will. I'm not interested in having a family with you, Ruti. Ruti said, but this is the only way I can have a child who's genetically related to me. I've lost my womb. I have no more eggs. Are you going to deprive me of that? A problem in many democratic liberal systems. We deal with this issue in American law. Case of Davis against Davis in Tennessee, 1992, where Junior Lewis and Mary Sue had a fallout after they were married, and there were eggs as a result of fertility treatment. Who was to gain the eggs? Mary Sue wanted the eggs as her right to her natural children in Tennessee. She called these fertilized eggs her natural children, and the mother has the right to them. The Supreme Court of the first instance court went along with her. The Supreme Court of Tennessee said, no, they are not your natural children. They are pre-embryos sitting in vitro in a refrigerator, and we are not going under democratic process to allow Mary Sue to realize her right to become a parent in defiance or at the cost of forcing Junior Lewis to become a parent against his will. In other words, if we have a rights-based approach, you cannot achieve your rights by forcing someone else to do something which they do not want to do. You cannot force a right upon them. So the democratic answer is, sorry, Ruti, but we can't do anything for you. Okay? There are variations on this theme in American law where we might draw up an agreement. We might give the eggs in the case of a dispute to the clinic, or we might have an agreement that says that in the case of a dispute, the court will decide who has the strongest interest in the eggs. But by and large, in New York, in Tennessee, in New Jersey, and in Massachusetts, the case of BZ against JS in 2000, the line taken by the court has been, this is a democratic issue, consent, autonomy is very important. And we're not going to force someone to be a father against his wishes. In none of the American cases, though, was there a case as tragic as this, where the party claiming the fertilized eggs had no other option of having a child. Okay? Although one case did say, well, even in those circumstances, we could always think about adoption. But the Israeli case is unique. Why? Because Ruti had no other possibility of having genetically related children.
That's a question.
Please.
It seems strange, I mean, the way the case is set up, that the eggs are fertilized. The cases that I vaguely recall from reading articles is that the eggs are not fertilized, but stored
Can't do that. You cannot store a fertilized, you cannot store an egg. You can store sperm, Anita, right? You can store sperm, but you can't store eggs. Eggs need to be fertilized. They will not last. Okay, they've got to be freshly fertilized in order to be refrigerated.
What if the medical turned on who fertilized the egg? You need the consent of the separated husband of his sperm was asked to fertilize.
Absolutely. That's why he says no. That's how the case came to court.
Right to have the eggs fertilized by somebody else.
She doesn't have any more eggs, and as soon as she lost her womb, she lost her egg supply. Now, the eggs that she had were fertilized with her husband's sperm. She'd had no other sperm providers. He was the only one. They assumed that they were going to go along with this process and eventually have a child. Ruti did make an argument along these lines. If two people go into a business partnership, can one pull out just whenever they want without making sure that the other party has not been compensated? Michael, what's your view? Can you just pull out of a partnership or a partnership agreement when somebody else has put money in? You made an agreement to form a partnership, and on the strength of that agreement, the other party has put out a lot of money, has bought equipment, has bought land, and is expecting you to carry on with the common enterprise. What do you think? Don't be shy. Do you think that they can just pull out whenever they want? Good enough. Thank you. This is a doctrine known in the law as, beginning with E and ending with L, E-S, estoppel. I knew that you'd know it, Reuven. Estoppel. You are estopped. You cannot say in certain arrangements whereby somebody else relied upon your commitment and your promise, you can't say, I never meant it. I didn't mean to go through with this. There is a doctrine called estoppel. And Ruti said, you started, you finish. There's no getting off the boat before it reaches the harbor. Okay? Now, does estoppel apply to this case? What do you think? Do you think we can force, using the law, Danny to go through with becoming a parent against his will? Because he did start. And Ruti relied upon this. She went through the hormonal stimulation, and she went through all of those tough things that she had to go through. There's a lot of emotional expenditure here and physical pain. Do you think she can claim estoppel? Would someone like to draw a... You say yes. Let me give you very quickly another example. A young man says to a young woman, I will marry you. And the young woman tells her parents, and everybody's thrilled, and they organize a fancy wedding. And then, a week before, the guy gets cold feet, pulls out. Do you think the law should force him to marry her, even though he's got cold feet? Ah, that was a quick turnabout there. You said yes, and then you said no, which is fine. The law makes this distinction, both the common law, or should I say equity, because it's equitable estoppel, and Jewish law, the law of partnership. If the situation changes drastically and is that type of situation where we're dealing with delicate and intimate human relationships, we do not estop, because to do so would not be the right thing to do. So Danny's case seems to be very strong. Democratically speaking, we don't force people to become parents against their will. You cannot exercise your right by forcing someone to exercise theirs. And, I'll just complete the sentence, There's no estoppel here. It's a delicate and personal matter. Becoming a parent is like becoming a spouse. We wouldn't want the law to force people into intimate, deep, and personal human relationships. If it doesn't come from the people themselves, then it's not going to be very healthy and very successful in the long run.
The situation
Yeah.
Randy is really not he's not really being forced to be a parent. He's now living with somebody else. The woman now was talking about having a child, so he doesn't necessarily have to be a parent. Parent is someone who's there.
Parent who is someone who is regarded by society or by the law as having a responsibility and a relationship with the product of their
Now, I would
gametes.
call that father.
Well, okay, parent and father. I
Parent is
think,
someone-
okay,
Parent would be someone who's a participant in the raising
I'm
of
happy
the
to
child.
say father against his will. Does that, if that rides better, that's fine. But you get the point. Here is somebody who says, I don't want my sperm to be used for a child with this particular woman. Okay? I'm going to continue a bit, and then I'll get back to you. The Supreme Court heard this case and went along with the arguments I just gave you a précis of. But they weren't happy. And I would hope that none of us are particularly happy. This is certainly democracy, Marty, right? But is it the right thing? Did we do the right thing? And the Supreme Court reconvened for what we call a further hearing, which you call en banc. All of the 15 Supreme Court justices in Israel got together to hear this case. It's interesting, though. You have about 300 million people here in this great country. You have 9 Supreme Court judges. We have 6 million. We already are up to 15 Supreme Court judges, and the number is rising all the time. May says something about the Jewish people. There was a further hearing on the eve of Rosh Hashanah, the eve of the Jewish New Year, which, as you know, according to the legend, is a time for barren women to be visited and to have children. Okay? Our matriarch, Sarah, and all other barren women in the world, according to the rabbinic legend, gave birth. So it is significant that this was on Erev Rosh Hashanah, and the further hearing of the Supreme Court found in favor of Ruchi Nachmani. Wow. How did they justify it? Well, there are 2 lines I'm going to lay out. Let's see how this goes. One is that for every law there is justice. And one of the important contributions of Jewish law has been that whilst there is law, there is also the need to imitate God and justice. He is merciful, you shall be merciful. He is gracious, you are gracious. Law must be tempered with justice and mercy. Okay? And there are going to be exceptional cases. It's called lifnim mishurat hadin, within the line of the law. And I will go out on a limb and compare this with the expression we use in English. We often talk, Reuven, of going beyond the letter of the law, okay? Beyond. That is, the law is basically not the vehicle that will take you to where a virtuous person needs to be. So you go beyond. The Jewish approach says you go within, lifnim mishurat hadin, within the law. We, unlike the Christian tradition, did not reject the law. Paul said the law is written on the hearts of the Gentiles. Leave and ignore the law of Moses. The Jewish approach, the rabbinical approach, says the law is a valuable polestar for life, but you have to go on an adventure of discovery into the law to realize its ethical and its justice bases. It's not sufficient to glide over the surface. And so individual cases require an individual solution. Talmud has many instances of the doing of something which is above and beyond, and here is within the line of the law. So the justices said, we know that in this case we are not doing law, but we are doing the right thing. We are finding for Ruti Nachmani. They cited Jewish law. There is a section in the Talmud that says that if a married woman comes to a court and says, my husband will not have children with me, the court will force him to give her a divorce so that she can have children with another man. Argument from here is that having children is an independent value of any commandments in relation to a woman, such as procreate, which may not be binding upon her. A woman can, in the picturesque language of the Talmud, ask the court to intervene when she is about to be deprived of a mara leyada and a chutra lekuvra. How's your Aramaic? Mara leyada, a stick for her to lean upon in her old age, and a spade, chutra lekuvra, to dig her grave. This is very picturesque, and there's an image here. If I unpack the image, we'd be here a lot longer than we really want to be. But there is support for the notion that it is a basic human desire recognized by the Jewish tradition to have a child. And having a child is a value and an obligation in a broad sense. The value of children, the fact that our matriarchs had to pray and go through all sorts of things in order to have a child. The basic and fundamental respect for the bringing of children into the world swayed and found a majority in the secular court, and I think that the discourse points us to another general conclusion. Earlier we talked about limited autonomy in the Jewish form, and we talked about the broad autonomy in North American law, and we wondered whether broad autonomy was always a good thing. So here we have an amazing technology, assisted reproduction. We can do all sorts of things. But do we have the moral responsibility to cope successfully with that? Do we regard procreation as an obligation as well as a right, or only as a right? And if the result isn't to our satisfaction, off we go. Many cases have come to North American courts where a couple entered into assisted reproduction halfway through, or a third of the way through, or three-quarters of the way through, or even after the birth of a child, couple is split, no more interest, and we have courts having to decide who shall become father, parent. It doesn't matter who. You commission this child, and now you say, I'm not interested. We put the best of human wisdom and presumably an ethical drive to make life better for the use of society at large, and we have a society which has shown itself to be, in a number of cases, entirely irresponsible. How are we doing on that? Perhaps, and this is my concluding sentence, perhaps a little procreative obligation mightn't be a bad thing. The Supreme Court held we are prepared to allow the eggs to be sent to the United States on condition that Ruti Nachmani signs a total waiver with respect to any obligations that Danny Nachmani might have under law or morality or ethics or anything like that. It will not cost him a cent. He will not be prevailed upon. As far as the law is concerned, he is out of the picture. But Ruti will have a chance to become a mother. Second case. I'm done. Reuven.
Question, what if the roles are reversed, and it's the father who wants the child and the mother who doesn't?
Same thing would apply. Same thing would apply.
And would the same result obtain in U.S. courts?
It would not have happened. In US courts, I suspect that when push comes to shove, the US courts would have said, sorry, this is autonomy, this is consent, we're not prepared to do anything to the fertilized egg of two gamete donors, and one gave the sperm and one gave the egg, without the consent of both. And if Danny digs his heels in, Ruti will not be able to have a child using her eggs and his sperm. Even on the condition, the court would not be prepared to enforce. Yes. Yes. Yeah. Yeah. The issue that is certainly true. The issue of rights of a parent is a ticklish issue, and I would be tempted to say much too much. I'm not sure that there are rights. I think that there are mutual obligations in terms of parent and child, but in terms of the spirit of your question, of course. He was. Yes. Under US law, we tend to regulate these things, and there are statutes that say eggs will be kept for so many years, then they'll be destroyed. Often, in the case of a dispute, there are two normal solutions. First of all, I should say that today, if you were to go for fertility treatment and you would contribute your eggs, you'd find that you'd be asked to sign on a very long form. And the form would usually have a clause about a matter of dispute, and would say something like, well, in the case of a dispute, then the eggs shall go in the first instance to the clinic. Okay? Unless one of the parties, because it could be used for another couple. It could also be used for stem cell research. Correct? Absolutely. Now, there will also be a clause saying, however, if one of the parties disagrees, then it shall go to court, and the court shall decide. And I've described what courts generally say. I can give you one last case involving the use of Jewish law in an English court. How's that? Yes? Okay.
You're destroying the fertilized egg.
Yeah.
That's
Not under American law, it ain't. Certainly not until 14 days. I'm going to throw the term primitive streak at you. Okay? You can do with it your worst. All right? But it means that at 14 days it's generally agreed, even by some members of the Catholic faith, okay, by the more liberal members, that the cells of the body become an organic unit rather than individual cells running around capable of choosing any career or life they want. And we're talking about freezing well before that stage. Under American law, this is not a living being, and we don't need to get into abortion. Let me take you to London. A couple has come before the Court of Appeals. They have Siamese twins. No? I said English court, Ruven, and I mean the English court. The Court of Appeals in the Strand in London. Those of you who've taken a stroll along the Strand may have noticed the Court of Appeals, those charming men in their wigs and in their robes and gowns. Okay. Now, couple have come with a pair of twins, conjoined Siamese twins, Cheng and Eng, the famous Siamese twins, okay, joined at the thorax. And Jodie and Mary are their names. They actually live on a little island called Gozo, which is very close to Malta. They are Catholics. And they were delivered in a hospital in Manchester, England. The surgeons wished to separate. Why? Our strong twin, they're both girls, it's a genetic thing, it's usually girls, called Jodie, has a normal heart. Mary doesn't have a very strong heart. In fact, minimal cardiac activity, minimal activity in her lung. She's basically living off the heart of her stronger sister. Now, what's going to happen in the course of time? If the twins are left to grow together, what's the medical prognosis, Terry?
That they're going to die because the weaker one will be taking too much from the stronger one.
Absolutely. One heart can't keep two babies going for much longer than 2 years. So what do? Physicians say we separate. The couple went to their priest, and they are Catholics, and he said, do not interfere. It is God's will. And they said, doctors, do not interfere. The physicians then went to court. That's what we do. When parents and physicians disagree, it's possible to go to court. After all, the courts are the symbol of the parens patriae jurisdiction, looking after the welfare of all members of society, the high priests of our ethics and of our morality. What are we going to do? If we separate, we kill the weaker twin the instant that the aorta is cut. But if we do not, then both girls will die. The horns of a dilemma. I'm going to give a background and I'll give you the last word. Okay? Worthwhile waiting. The court held in favor of the physicians, but it had a problem with English law. Looking at it from one respect, what are we doing here? We are killing one innocent person to save another innocent person. Are the twins not innocent? Does Mary plan to kill Jody? Certainly not. So how can we justify that? We have a famous case of the shipwrecked mariners, 1884, Crown against Dudley and Stevens. The English sailors set sail on their way to Australia, and they spent 280 days on the open ocean in a lifeboat. In the end, they ate the cabin boy. First of all, they drank his blood. And when they were charged, because 3 days later a ship came by, Anita, and picked them up, they said, necessity. We balanced our lives, 3 of us, against the life of the cabin boy. The numbers game. We sacrificed him so that we could live. Otherwise, we would have all have died. English law said, using the words of a famous Jewish American judge, Benjamin Cardozo, the common law does not recognize a principle of human jettison. We don't throw people overboard to save the lives of the rest of the crew. By the way, does this apply in Jewish law and tradition? Who did we throw overboard to save the rest of the crew? Jonah, exactly. And the mariners knew that. They said, Jonah. And the English and the Victorian judges said, Jonah doesn't impress us. We do not recognize the principle of human jettison. So the judges wanted to decide in favor of the separation, but where was their precedent? They didn't have one. The defense of necessity, to get technical for a minute or two, only applies where there's an immediate and direct threat to the person who's contemplating doing the wrong deed. But here, it's a decision taken in cold blood. We're all in the same boat, in every sense of the word. It is remarkable that the judges of the English Court of Appeal in London went to Jewish law. Another example in this area, Jewish law. They read an article by George Annis, who is a professor of biomedical ethics at the University of Boston, in relation to a case that took place in 1977 in the Philadelphia Children's Hospital, involving a pair of Siamese twins born in the same way. Except this time the parents were Orthodox Jews. They came from a town in New Jersey beginning with a letter L, ending in a letter D. Can anybody guess? Lakewood, exactly. very orthodox. And when Everett Koop, who was later on to become the Surgeon General of the United States, put to them the suggestion that a team of medical experts separate these twins, the parents then went to the same sage of the Lower East Side we mentioned earlier, Rabbi Moshe Feinstein. And 32 hours of telephone conversation ensued between Rabbi Feinstein and the medical team. Rabbi Feinstein used two examples drawn from the Talmudic tradition. One is a group of travelers, say us, we here. Through those doors, unfortunately and sadly, burst a group of armed men with evil and murder written all over their faces. And they say, give us one of the group, we will slaughter that individual, and the rest of you will be let loose and will live and continue to listen to the lecture. What would we do under Jewish law? Liana. We don't know yet. Do we pick and select and ship out? No, we don't. Say they come in and they say, we want Liana. Okay? What do we do then? Yes, you have read the Talmud. We give her up. But one view is only if Liana deserves to die because she's committed a capital offense. Correct, Liana? Well, there are two views, and there is an analogy. We had a case in the Holocaust. Jews were in a bunker. The Germans were overhead. A baby started to cry. The father of the baby stuffed a rag down the baby's throat to stop the noise, because on being discovered they will all have been slaughtered. When the Germans passed and the rag was removed, Ellen, the baby, was dead. And after the war, the father, who had never recovered from the trauma, went to a rabbi who was himself a survivor, Rabbi Oshry, and asked whether he was to be considered a murderer, and if so, what his penitence was. Rabbi Oshry referred to the case of the travelers and said, whilst there is a view that you have to be guilty of an offense, that definition is wider. He plays with these terms, and he says that the term used actually to describe a person guilty of an offense is not the standard chayav mita, liable to the death penalty, but mechuyav mita, that is objectively sentenced to death. And Rabbi Oshry said, because this whole group was objectively sentenced to death, the Nazis discovered them, Nazis killed Jews, period. Therefore, the baby was also sentenced to death, not judicially, but objectively. And in any situation where there are individuals who are objectively subject to death, then one may weigh and balance in favor of those who have a chance of survival. And that's how Rabbi Feinstein solved the problem. He wanted to know exactly which was stronger and which was weaker. Since both will die, one is designated because of the weaker status. When the doctors convinced him that it was Mary who was the one who would die, he was able to say, apply Jewish law. The parents agreed. The operation was done. The separation operation was in fact a success. Back to London. The judges read the article, used the term designated to die, and said the Jewish law provides a solution here. We are departing from a tradition in English law that says you may never balance one life against another. The Jewish people has been in many difficult situations and has developed, if you like, a more finely texted approach for dealing with these tragic questions of life and death. But I am going to conclude, and I think I should conclude, correct? With, this is my last point, with a sentence by Maimonides in relation to this case of the travelers. Maimonides says, "Aval en morin lahem ken milechatchila." But we do not teach this law in the first instance. Be very attentive, please. If we happen to be in the room and the brigands burst in and we were faced with this tragic choice, it would not be the correct thing under halakha to pick up a Palm Pilot or use our mobile phones, call the local rabbi and say, "What shall we do? Rabbi, what's the law?" And he or she will summarily trot out laws of the principles of the Torah, chapter 5, subsection 5, give her up. She was named and she's guilty and she'll die anyhow. We as individual Jews have to make difficult moral choices on our own. And we then look to the law to justify what we have done. We never give up the moral tension here. There has to be an element of doubt because we are both servants of the law and we're also human beings who have a divine spark and must act and work in accordance with that spark. So there's always the interplay of the two. Autonomy is not a value, but we have to listen to people in situations where they ought to be listened to. To have a child needs consent, but sometimes we have to realize that procreation is an obligation and not only a right. And the saving of life is an absolutely cardinal value. But when you have a tragic choice to make, you have to take into account how the situation will pan out. And sometimes you have to say who will live and who will die. That is a task of God, but sometimes human beings do that. And we pray that they do it with sensitivity, with a moral background, with a deep steeping in the wisdom of the past, so that those decisions, and we make them in the medical field every day, are made wisely and well. Thank you for your attention. Yes, Reuven. But just a second. You wanted... Great.
This is just a technical question. Your first two examples occur in Israel. Israel's legal system is not a Talmudic system. What is the basic non-religious legal system?
Israeli law, lehitraot, and thanks. Israeli law is a secular system in every area other than marriage and divorce. But as I mentioned to you earlier, there was that 1980 law that said that if a judge can't find an answer to a legal problem in existing case law, legislation, or by analogy, then the judge shall turn to the principles of equity, freedom, justice, and peace of the Jewish heritage. So Israeli law uses Jewish law as a safety valve. And I'm going to use the question, as lecturers often do, to give you, if you like, a valedictory case. Marital rape. Okay? Can a husband? What does the law say about a husband who forces his wife to have coercive sexual relations with him? Is that rape? We have a legally married couple. The husband has forced his wife to have sex with him. Is that rape? No. Yes. Have a great evening. Ellen says no. Reuven says
Yes, I say yes.
yeah, I didn't finish the sentence. Well, both are right. Up until fairly recently, it was held that a man who is married to a woman has a right to her body in English law, in American law, in Australian law, etc. What is it based upon? A Christian doctrine, the marital debt. Paul said better to marry than to burn. Marriage is there for the male to channel his sexual drive. If the wife says no, then what's marriage for? In fact, Sanchez, the famous 17th century Jesuit teacher, considers the situations under which, Ellen, listen carefully, a woman might be excused from the marital debt. He devotes a lengthy volume to the headache excuse. But it is not sufficient. I have to assure you that according to Sanchez, it is only a headache plus a fever which will let you off the hook in terms of the marital debt. Headache alone is not sufficient. This is the common law. Have you read the Forsyte Saga by John Galsworthy? Well, okay, gap in your Victorian education. But Soames, the nasty guy there, forces his legally married wife, against the agreement they entered into, Michael, to have sexual relations, and he says, this is the common law. Okay? Now, there was a case in Israel. Moshe Cohen was a Jew, burst into his estranged wife's apartment, forced her to have sex. Common law is the basis for Israel's criminal code. The criminal code of Israel follows common law. And Reuven says, if you're legally married, it ain't rape. It's something else. It's not rape. Correct, but not correct. Because in that case, Jewish law was entered into the plea. The prosecution used the terminology of the phrase, of the clause, section 365 of the 1977 penal law, which said that any intercourse which is not legal, and said that doesn't mean legal under common law, it means legal under the personal law of Moshe Cohen, because Jews in Israel have both a general law and a personal law. Personal law of Moshe Cohen said, and this is a Jewish position, who has a right to whose body under Jewish law? Last week's Torah reading, Mishpatim, what does it say? She'ra ksuta v'onalta lo yigra. A Jewish husband cannot deprive his wife of sexual gratification. And there's no concomitant biblical right for a Jewish husband. Reuven. So under Jewish law, the prohibition is on the husband forcing his wife, because it is she who has the right. Now, nobody in fact is forced, and that's the basic difference. So Moshe Cohen, under Jewish law, was found guilty of rape. And by the way, most of the legal systems that we live under have changed in the last 10 years. The House of Lords held out in England till 1991, the case of R against R. And it laid that disgraceful precedent to rest. Jewish law then provides us with an extremely liberal democratic solution. The question, Reuven, was then asked, what would have happened had it not been Moshe Cohen but Musa Khalil? And had it been a Muslim tradition that a man does have a right to his wife's body, or a Christian couple, what then? And the Supreme Court declared that once Jewish law enters the secular system of the State of Israel in terms of equity, justice, freedom, and peace, then that is law for all citizens, all races, and all creeds. That is Israeli law. This is halakha working in perfect synchronization with democracy. I thank you. I assume. Great.
Thanks for listening. For more information on the 92nd Street Y, New York, and all of our programs, please visit us at 92ny.org.